Hi, my name is Carl Pearson, and this is video number 127 on Massachusetts laws on wrongful foreclosure. I'm a New York attorney, spending most of my time defending against home foreclosures throughout the 50 states, and I have come across the Massachusetts laws, and I wanted to give you an insight into Massachusetts foreclosures. I've had experience in Massachusetts law as a Harvard Law School graduate and experience after that. Massachusetts, from a foreclosure law standpoint, is a non-judicial foreclosure state in spite of the slight judicial contact that's required with a land court under Massachusetts foreclosure law. This slight contact is merely to ensure that the homeowner is not in the military service actively, and it has almost no effect on most foreclosures. I'm creating this video to explain how foreclosure defense and foreclosure remedies work in Massachusetts, because Massachusetts has some interesting and useful statutes, if properly and timely employed, to substantially offset the adverse fact that Massachusetts is one of the 28 non-judicial foreclosure states. What this means to me is that if a Massachusetts homeowner threatened with foreclosure retains a knowledgeable foreclosure defense attorney at the outset of a threatened foreclosure, the homeowner has a much better chance of keeping his or her home than if he or she waits until a threatened foreclosure has matured with the passage of time. Please note that I'm not saying that you can wind up with a property free and clear of the threatening mortgage foreclosure sale and subsequent eviction. What I'm saying is that if you raise enough substantial legal issues in opposition to a threatened or actual foreclosure, you stand a much better chance of keeping your home with an affordable loan modification agreement. The lender and servicer will be more apt to give you an affordable loan modification agreement to be able to end your lawsuit against them. What I would like to suggest at the outset is that I am able to work with local Massachusetts attorneys in defending against Massachusetts foreclosures if the homeowner has difficulty in finding a local defense attorney, or in working with a local Massachusetts attorney who wants some legal support. I can prepare the required legal documents for review and approval by the local Massachusetts attorney. I would be needed only if the homeowner is unable to find an experienced Massachusetts attorney willing to take on the matter for various reasons. But let's put that aside and talk about Massachusetts law relating to 1 to 4 unit residential foreclosures. Let's start with the appropriate court for the defense activities, which would be the Superior Court in the county in which your mortgage property is located, or possibly your own county if that differs, and not the land court or probate court or district court. The Superior Court is where wrongful foreclosure actions are commenced. Non-judicial foreclosures are permitted if the mortgage contains the provisions set forth in Chapter 183, Section 21, quote, statutory power of sale, unquote. An attorney preparing a wrongful foreclosure complaint or an injunction action to stop a threatened wrongful foreclosure should review this statute and allege that the foreclosure violates such section because of the violation of various other Massachusetts statutes and some common laws that I'll start describing in this video. Please note that I'm not going to be going over various federal statutes that could apply as well and should be taken into account when drafting a complaint. One of the main Massachusetts statutes defines a, quote, predatory loan, unquote, which makes it easier to raise a predatory loan defense to foreclosure than it is in most states. This statute is Chapter 183C, that's 183C, called the Predatory Home Loan Practices Act, a sweeping statute with 19 sections. In most states, predatory loans are not defined by statute, and alleging that a loan is predatory does not do any good. In New York, for example, a claim that a loan is predatory itself does not state a cause of action, and the claim will be dismissed. The activities claimed to be predatory have to meet the requirements of causes of action called something other than, quote, predatory loan, unquote. Another highly useful Massachusetts law is Chapter 93A, the Consumer Protection Act, which is the most used statute when asserting a claim for wrongful foreclosure. This statute is a deceptive practices statute, and comparable legislation is found in most states. The statute in Massachusetts has been upheld as the basis for wrongful foreclosure actions, and the attorney's job is to make out a case for deceptive practices relating to the threatened or actual foreclosure. This statute enables a homeowner to obtain relief even when the note holder's or its servicer's activities do not rise to the level of common law fraud. If there is common law fraud, you would want to include this claim of fraud as a separate cause of action in the complaint. Another statute relating to predatory loans is the Massachusetts Borrower's Interest Act, Chapter 183, Section 28C, which makes it illegal to refinance a mortgage loan, which could include a loan modification, within the first 60 months unless the new interest rate is in the homeowner's favor. This statute is reminiscent of the anti-churning statutes in most states relating to sales of insurance policies to replace existing insurance policies. Another useful statute is part of Chapter 244, Foreclosure and Redemption of Mortgages, Section 35A. The title of 35A summarizes the statute, and you should listen carefully because these are some of the opportunities for defense. The right of residential real property mortgagor to cure a default. Good faith effort to negotiate for commercially reasonable alternative to foreclosure. That's a big one. Response from borrower. Affidavit upon initiation of foreclosure proceedings. Acceleration of maturity of balance prohibited. Notice. When drafting a complaint, the attorney should review the various provisions in Section 35A to ensure that any appropriate causes of action are stated on the facts that you have to allege in the complaint. Section 35A is not the only statute in Massachusetts having a notice requirement. The attorney should also look at Section 14, which provides a statutory notice requirement for a non-judicial foreclosure pursuant to a power of sale and a form to be followed. A foreclosing party is required to adhere strictly to the notice requirements, otherwise the foreclosure effort is void. An attorney, when drafting a complaint, should make sure to review all of the notice requirements to find any requirement that was not met or arguably not met. Some of the possible claims for wrongful foreclosure relate to the origination of the loan, and the attorney preparing the complaint needs to determine to what extent the envisioned defendants are liable for illegal loan origination activities which may be cut off, or on the other hand, the liability allowed by provisions of the Uniform Commercial Code. One set of possible claims may be derived from Chapter 140D, called Consumer Credit Cost Disclosures, consisting of 35 sections. There may be a cause of action based upon failure to provide the credit cost disclosures at the origination of the mortgage loan or mortgage loan modification transaction. Another useful statute is Chapter 93, the Massachusetts Antitrust Act, entitled, quote, Regulation of Trade and Certain Enterprises, unquote, which states that it is to be interpreted in accordance with Section 1 of the Sherman Antitrust Act. It's a federal statute. Major banks and servicers are violating federal and state antitrust laws by not permitting mortgagors to participate directly or indirectly through friends, associates, or relatives in short sales of the mortgage property and in any transactions involving sale of the defaulted note and mortgage. I have been an antitrust lawyer for small companies most of my life as an attorney, and these antitrust violations only became evident to me in January 2014, even though I have been defending foreclosure actions for years. Antitrust is complicated because of the numerous and changing court decisions and the usual lack of information as to the actual facts involved, which are often closely held secrets, and most attorneys have little experience in antitrust litigation to complicate the matter further. As a result of these antitrust violations, which themselves are causes of action for a complaint, There are additional causes of action under Massachusetts law which arise as a consequence. The lender and its servicer have a duty under Massachusetts law to provide the full range of possible loss mitigation options to a homeowner threatened with foreclosure. But because of these antitrust violations, the options of short sale and discounted purchase of the defaulted note and mortgage are illegally taken off the table, so that the homeowner is more apt to lose his or her home as a result. The attorney drafting a complaint should include any facts which show that the homeowner was denied some of the loss mitigation options to which he or she was entitled under Massachusetts law. This ends my review of Massachusetts statutes. As you can see, it is very complicated and requires a lot of study and application to the case at hand. Homeowners attempting to do this on a pro se basis will probably miss about 80 to 90% of the possible and needed factual allegations and have little chance of succeeding, in my opinion. This is also true, but to a lesser extent, as to any attorneys not highly experienced in foreclosure defense and wrongful foreclosures. The best combination, I believe, for a threatened homeowner is to retain an experienced attorney wherever he or she may be located to draft the required complaint and any motions or orders to show cause, and to then retain a local commercial litigator in the homeowner's county to represent the homeowner by reviewing and making any required changes to the documents and filing them in the local superior court and representing the client in that court. If the local attorney has sufficient experience with foreclosure defense and wrongful foreclosure, the homeowner may not need the first attorney. My experience, however, is that it is difficult for homeowners in each of the nation's 3,100 counties to find a suitable attorney to litigate foreclosure matters against banks, other note holders, and servicers for a variety of reasons which are really too complicated to go into here in this video. Now, as to Massachusetts case law, there are some leading judicial decisions in Massachusetts which the attorney drafting a wrongful foreclosure action should be familiar. The first case must take into account, the first one to be taken into account is the 2012 decision in Eaton versus Federal National Mortgage Association, which held that the mortgagee has the right to foreclose even if it does not hold the related note. The traditional standing issue in most of the states was overturned by this decision in Massachusetts. The note presumably is being held by the bank or lender authorizing the mortgagee to foreclose. Secondly, U.S. Bank National Association versus Ibanez, a 2011 decision which held that if proper notice to the mortgagor was not given, the foreclosure sale is null and void. Third, Qatar versus Demoulas, a 2000 decision that violation of the Consumer Protection Act can be the basis for a wrongful foreclosure action in Massachusetts. Fourth, a recent 2013 decision in Dracopoulos versus U.S. Bank National Association. The Supreme Judicial Court discussed many of the statutes I talked about before, as well as the common law claim of unconscionability. The facts were not in dispute. The mortgagor had income of only $1,900 per month, and the monthly payment on the mortgage at 10.315% was $2,573.02, or $600 more than the mortgagor earned each month. Finally, a 2008 decision, Commonwealth versus Fremont, which held that a lender may be liable under the Consumer Protection Act, Section 93A, for, quote, the origination of a home mortgage loan that the lender should recognize at the outset that the homeowner is not likely to be able to repay, unquote. Two characteristics were emphasized, quote, an adjustable rate and that a lower introductory rate lasted for a period of 3 years or less, those two factors. I've now said what I set out to say, and I want to repeat that homeowners in Massachusetts have an advantage over homeowners in most, if not all, of the other 27 judicial foreclosure states because of the various Massachusetts statutes that have been enacted to try to level the playing field for homeowners. Also, there are a variety of common law causes of action that need to be considered for inclusion in any complaint for wrongful foreclosure or threatened wrongful foreclosure under Massachusetts law. But I do not have enough time in this video to discuss the many causes of action that should be considered to give the Massachusetts homeowner the best chance of saving his or her home. There are a variety of Massachusetts decisions which discuss these various common law causes of action. To give you some insight, it has taken me more than 20 hours to put together and analyze the Massachusetts foreclosure laws, and it would take a lot longer for someone to do this properly who does not have substantial experience in foreclosure defense. The amount of legal knowledge needed to afford a threatened homeowner the best chance to save his or her property is extensive and requires, I believe, an attorney with substantial foreclosure defense experience and a knowledge of Massachusetts law to draft the appropriate complaint and motion papers, assuming that the Massachusetts homeowner can't find a suitable local attorney to do this. These documents can then be used by a local Massachusetts attorney, such as a commercial litigator or possibly a civil rights litigation attorney in the appropriate county to pursue the homeowner's remedies with the best chance for success. The local attorney would be able to consult with me as the case progresses, but will find, especially if the local attorney is a commercial litigator, that there will be decreasing or even a non-existent need for any further services by me, which is quite all right with me. I have plenty to do already, including the making of my videos. If you have any questions, please give me a call. Now, one last point. If you retain me to prepare your complaint before seeking a local attorney, it should prove easier and less expensive for you because you will be able to use my complaint and any motion papers to show the local attorney exactly what is involved. I will be better able in my complaint and my motion papers to explain your case than you could yourself without such papers. So once again, if you have any questions, please give me a call at 212-307-4444. I look forward to hearing from you.